Welcome to Unit 2, Lesson 2 of the Introduction to American Law. In this unit, we are discussing litigation, which is the court system's mechanism for dealing with disputes between individuals. In this lesson, we will discuss the process a case takes from the initial dispute to the court. And we will also discuss what happens when there are multiple parties to the same lawsuit. So let's begin by discussing what happens from that initial dispute in order to go to the court system. In this lesson, there will be tons of vocab and there will be tons of different options as to what can occur throughout different cases, so make sure that you are taking detailed notes and really paying attention to those vocab words that do come up. So, litigation begins with the dispute, with whatever the problem is between two individuals. Whether someone rear-ends your car, or robs your house, or beats your dog, whatever the dispute may be, it can eventually lead to a court case. So, when the initial dispute occurs, then there are a couple of options. One, the parties can do nothing, essentially, which leads to the end of the dispute. Or two, then the parties could settle the dispute with each other right then and there. Maybe someone loses your wallet, so then they pay you back all the money that was in your wallet and buy you a new one. Case closed. There's no need for further action. In this case, then this dispute would die before reaching the court because either the parties avoid conflict or the conflict is resolved at the initial dispute. What could happen next, say the issue is not resolved, is that a party can recognize legal action as a viable option in this case. What occurs then is basically maybe someone rear-ends your car and you get injured in the process, and you don't resolve that dispute on the spot. Maybe you realize that, hey, potentially I could sue this person to help pay for my medical bills because I got injured because of something they did. In this case, you basically have two options. You could pursue legal action or not pursue legal action. In this case, in this step of the process, the case could die because either maybe you see legal action as too time-consuming because that would be a very extensive process you would need to go through. Or maybe you don't have enough money to pay a lawyer, or you can't miss that much time of work, so it would be too expensive for you. Or maybe the whole lawsuit process is just too emotionally draining. In all of these cases, then your dispute would never reach the court. However, if you do decide to pursue legal action, that would lead us to the next step. In this step of the process, you can either choose to obtain a lawyer or represent yourself pro se. Pro se just meaning by your own, that's a Latin term. In this step of the process, then your case could die, meaning never reach the court, because your lawyer might not think there are enough facts for the case to be effective, or your lawyer might not take your case because you might not be able to pay them. In these instances, your case would die and not reach the court. However, if your lawyer does decide to take your case, the next step of the process is to formally file a complaint with a summons attached. These are vocab terms, so make sure you are taking special note here. What happens when the plaintiff files a complaint, or normally the plaintiff's lawyer, if the plaintiff is not educated in lawsuits, then the defendant has a few options now. After the plaintiff files a complaint with the summons attached, then the defendant has a few options for how they respond. Number one is the defendant can completely ignore the plaintiff's formal complaint And number 2 is that the defendant could respond to the formal complaint. If the defendant doesn't respond to the plaintiff's complaint, then the plaintiff will typically file a default in response. A default basically is a plaintiff's move to gain resolution to the case without the defendant involved, because the defendant, when they don't respond to the complaint, they basically show lack of interest in the proceedings. However, if the defendant does respond, they normally do a few different things. Either A, they file a motion to dismiss, meaning that they read the complaint and they don't think that there's enough legal basis in order for the case to go to court, so they file a motion to dismiss. The defendant can also file a demurrer, which is basically another fancy name for a motion to dismiss, specifically stating that there is no legal basis for the case to continue. Or the defendant could file an answer, and an answer basically says it addresses the claims that the plaintiff brings, and they respond from there. So, for instance, the defendant could deny that the plaintiff's claims are true, saying that that didn't happen, or the plaintiff might, or the defendant might say that yes, the allegations are true, but for reasons ABC, it is not in violation of laws, or the defendant should not be held responsible for their actions. In this step of the process, the case can die again because, 1, the plaintiff could get default judgment, meaning that if the plaintiff files a default, then they could receive default judgment, meaning the judge makes a decision without the defendant being part of the process, so the case doesn't officially go into a full-blown trial. The second reason the case could die is if it is dismissed. How this occurs is that when the defendant files a motion to dismiss or a demurrer, then the judge could decide that there isn't significant enough evidence to bring the case to trial, so the case would die. And then the third option here that can technically occur at any spot or at any time along the process is settlement. What settlement means is basically the two parties get together and they come to a decision without having to formally go to court. However, if the case does not die at this point and continues forward, we move on to discovery. The only way that the case can die during discovery is through settlement. So, for instance, maybe through the evidence obtained by the process of discovery, the parties settle because one party sees that they probably will not win a court case. So, seeing that they would not win the case, they decide to settle. During discovery, a few different things can happen. Discovery is the process of each party sharing evidence with another party in order to see that they each have what they need in order to build a substantial case. In order to do this, then they might carry out depositions, which are formal interviews between the parties. Maybe they issue interrogatives to each party, which is basically written questions, so not an on-the-spot interview, but an interview through written word. Another option that a party might take advantage of in discovery is demanding for another party to produce evidence. So maybe they want to see another company's business receipts or security footage or anything of the sort, so they demand for the other party to supply that. Or you can even ask another party to submit to a physical examination, probably in cases where a party's physical ability is the subject of dispute. If a case moves past discovery, then it finally reaches trial, and we will discuss the trial process in the next lesson. So for the remainder of this lesson, we will talk about how to deal with a suit that concerns multiple parties. In some cases, then multiple defendants are the subject of the suit. So, for instance, if an individual has a problem with their car, maybe their engine blows while they are driving down the road and someone is injured, they could sue maybe the manufacturer of the car, they could sue the dealership who sold them the car, they could sue the company that transported the car overseas to the dealership. There are numerous possible defendants in this case. So let's discuss what happens when there are multiple defendants to the case. One option is impleadment. Basically, what impleadment is, maybe someone's getting sued, but they think someone else is at fault as well, so that person can implead another defendant to join the case. What occurs here is, instead of the plaintiff suing one person, then the plaintiff finds themselves suing 2 or 3 people. Another complicated process is a cross-claim, which basically means that within the original lawsuit of a plaintiff suing another defendant, then 2 defendants are suing each other at the same time. One other option that might be more simple to understand is the counterclaim. What happens here is a plaintiff sues a defendant, and in response, the defendant sues the plaintiff back. There are multiple ways that the court can settle a dispute between multiple defendants. If there are multiple plaintiffs, the most typical scenario that the court system encounters is a class action lawsuit. Basically, if a court is charged with hearing a bunch of different cases that are against the same defendant, and all of the plaintiffs are in similar situations, they basically pool all of those cases into one, and it turns into a class action lawsuit. So, for instance, if 100 different people have problems with a big pharmaceutical company for the same thing, they might all team up in order to sue that one pharmaceutical company for the same thing. So in this lesson, we've discussed what happens from an initial dispute between individuals or parties and how that leads up to trial. And we've also discussed how the court system handles suits with multiple parties involved. And all of this is part of the litigation system, meaning all of this is how the court system resolves disputes between different parties.